let's try to break down some of what was going on in the last story that we talked about there. This bus crash bus driver who is now in trouble for allegedly having sex with a 14-year-old. Michael, what do you make of it?
Oh, boy. And this, I understand, was going on when he was out on bond for the original Problems. So he had some free time. He's out on bond. He's also trying to get his bail reduced. All of this happening procedurally, and he's allegedly having a little dalliance with a 14-year-old girl. Come on.
I mean, is that what you're supposed to be doing when you're out on bond?
You know, good behavior...
The answer, of course, is no.
Yes, thank you. Good behavior is normally better. But this guy's gone way beyond bad behavior. It's not going to help his case, and certainly for a young girl to be taken advantage of. I mean, it just makes a bad story even worse.
How bad can it get for him?
If we're talking about an individual crime for an act against the girl, it could be an aggravating circumstance in the underlying crimes, but it could stand alone as a crime that gets him more years added to any sentence as a totally separate standalone crime.
Yeah, we're going to keep an eye on that one. It's a case that a lot of people are watching. We weren't able to stream it. But certainly the seriousness of the bus crash stood on its own, and then you've got somebody out on bond getting away, at least temporarily, with much worse or something that's almost as bad. You know, a lot of times courts let people out with the presumption that they're going to come back in, and they think the punishment's enough to prevent any other bad acts. Might judges, at least in that municipality, turn around and say, look, we don't want to let people out on bond anymore because look at what this guy did?
It's going to be an issue. You know, there's always crowding issues. There are a lot of things that go into determining whether a defendant should be released on bond, on OR. And now the barn door's been opened for this guy. He's out. He's done additional bad things. Will the judges use that as a reason to be stricter for defendants going forward? I don't know, but they got to think about that. Yeah,
well, Michel Byant, former Court TV correspondent, current attorney. We're going to continue to break down this other case that we're following, this murder of a U.S. Marine who is out celebrating his wife's birthday. If you're just joining us here in the noon hour on Law and Crime, we're going to bring you up to speed on that case against two defendants, Quincinio Canada and Duan Mulazem. Then we're going to start breaking down more of the testimony from the witnesses who say that they were attacked in a hotel room 6 days before the murder happened.
The Kentucky trial of the shooting death of a Marine is underway. 26-year-old Quincinio Canada and 34-year-old Duan Mulazem are charged with murder and assault for an incident outside a bar in 2014. The two men allegedly approached Corporal Jonathan Price and his wife Megan when one of them tried to snatch her purse. When Jonathan got involved, a fight started, and the corporal was fatally shot in the back. Megan suffered a non-fatal bullet wound to her leg. Both men are also charged for a robbery 6 days prior to the Price shooting. Law enforcement connected them to both crimes by identifying the .45 caliber handgun used in the robbery and the shooting. For Law and Crime, I'm Rachel Stockman.
And it's testimony about that original robbery at the hotel that really kicked off the murder trial here that we're watching on Law and Crime. As we review testimony in that, let's keep in mind that the game prosecutors are playing here is to take the testimony about the attack in the hotel room and then try to say that the weapon that was stolen in that hotel room attack was the same weapon that was used to murder that U.S. Marine corporal. That's the critical link. That's what prosecutors are aiming at here, but there are big questions as to whether it really was the same gun. The ballistics tests apparently indicate that it was, but the eyewitness, the surviving widow of that U.S. Marine corporal, described a weapon different from the weapon that authorities believe was actually used in the crime. How are they going to deal with that discrepancy? We're going to find out more when the trial picks up again on Monday. But in the meantime, let's continue to listen to some of that testimony from the victims of that hotel room robbery. That's the prosecution opening statement in the murder trial of U.S. Marine Corporal Jonathan Price. He was shot and killed while protecting his wife during a robbery attempt outside of a tavern. Michel Byant is a former Court TV host. He's with us here on Law and Crime now. So, Michael, they're making a big deal about the weapon here and the testimony yesterday from the widow herself. It was heartbreaking to watch, but there are issues about whether or not the gun that she identified is the gun that they're talking about in these opening statements.
You know, it was an interesting point because up until that testimony, which identified one of the guns as having some sort of shininess to it,
or it was silver,
or silver,
were the
and
words that she used.
the other being a revolver, so that's off the table. The one,
Yeah.
the subject gun was not a revolver; it was a semi-automatic, but it's black on black on black. So the question really becomes: did she really see that flash? Was she, in the heat of the moment, just misidentifying what she saw? What is the least reliable evidence in any trial? Witness ID testimony. It's just not good. Now, we have ID issues here with the defendants, but now we have a witness maybe not IDing the gun properly either because of what was going on at the time.
Well, that raises an interesting question because the widow was very careful to say, I didn't want to pick the defendants out of a photo lineup because I didn't want to be responsible for making the wrong choice. So in her own head, she's choosing what facts she's sure of and which facts she's not. But she's really clear about the gun. It was silver. So why didn't she say, well, I didn't get a good look at the gun?
Interesting. I mean, who knows? Maybe she saw a muzzle flash. Maybe she saw something that in her mind
reflected off of it. That could be too. I mean, it is metallic after all.
And there is enough other evidence suggesting that is the gun. Now, I got some issues with the gun. I flashed back to college days. Remember your film appreciation class? You took one. Come on. You know, that's one where you say, easy
drama
A,
theory on
I get to
film.
go watch movies? I can do that. Do you remember the MacGuffin? That was that movie tool that we see now in movies, too, that moves characters or moves the plot. Somehow it's an item that moves the story along. Raiders of the Lost Ark, it's the Ark. You get it. So in this case, it's this gun. This gun absconded, 6 days earlier in a prior robbery, now shows up as the apparent murder weapon here. But what the heck's been going on in that 6 days with that gun?
Yeah, how does it get from the defendant's hands, if indeed they had it, to the person who sold it to federal authorities, which is why the authorities wound up with a weapon in the first place? And is the person who sold it to the federal authorities going to testify in this case? Is there a Fifth Amendment issue? Is there going to be an immunity? You're right. There are a lot of issues wrapped up in this. But look, one of the other critical pieces of testimony that came out, pieces of evidence that was played here thus far in this case, which is still moving along once the jury gets back into session on Monday, is the 911 call from the people in that hotel room who were robbed 6 days before the murder happened. We want to play that 911 call now. That was a 911 call placed by Jessica Hansford. She was one of the victims in that hotel room robbery where prosecutors believe the defendants in the Jonathan Price murder case made off with a weapon that they later used to murder that U.S. Marine corporal who was out celebrating his wife's birthday. It's a long chain here of evidence, but the links are key because the prosecution doesn't have a lot of evidence directly linking these two defendants to the crime, at least not yet. Michel Byant, you were watching that 911 call being played along with us. What's your take? You had an opinion that you were forming about the witness's reaction to her own call.
Which is as important, really, for the jurors as what they're listening to is the witness's reaction. Maybe she's just nervous, and it's it's a very stressful setting on the witness stand, but she had sort of a smirk on her face as she's listening to her own 911 call. I don't know if it was just very nervous for her or what. It just seemed very odd affects.
And maybe she was reacting to something the defendants were, were they shooting her weird looks? We're not seeing that part of this either. We're just seeing her. Maybe something was going on there.
Yeah, it's hard to tell. Something very important about this 911 call that if I were the defense attorney, I'd be latching onto. She was clearly upset when she was making this call. She was hysterical. She was freaking out.
And that's understandable.
Understandable. Somebody's pointing a gun at you or your friend or both, and it's a violent event. How good is anything she has to say from what she's recalling from that night? How tainted is it by the emotion and the fear of that night? So whatever she may have that points to the defendants may be suspect because she really was out of her head. She was freaking out, understandably, but if I'm representing the defendants, I'm going to shoot holes in any identification she provides. She could barely have a phone conversation.
Yeah, these are key points. Look, we're going to listen to this witness's testimony again. This is Jessica Hansford. She was one of the robbery victims at that hotel 6 days before the murder of the U.S. Marine corporal. Here's her testimony. Testimony there from Jessica Hansford, who was among the people who were robbed at gunpoint in a hotel room. They were visiting the Lexington, Kentucky area from out of town, and they were about to attend a gun show. She talked about feeling the weapon up against her head there. Michel Byant, former court TV correspondent, current attorney. Look, harrowing moments, difficult testimony to recall. She recalled it clearly. I think that we're going to believe her version of events.
I think unless somebody directly contradicts it, sure. You still have to attack the credibility of what's going on in the moment in her head. She seems to be pretty detailed about what she heard and what she felt and what she saw. But I think that 911 call immediately after may be more indicative of her mindset than as she quietly and calmly recounts it from the witness stand.
Yeah, and look, one of the critical pieces of this that came out there was this statement, come on, uncle, or come on, nephew, and they're referring to one another as uncle and nephew. Now, these two defendants are indeed related in that manner. So, again, is this the smoking gun evidence here, or is it a couple of people who are trying to set these two defendants up? What do we make of it? Is it enough to really say definitively that these two are the ones who did it?
Definitively, I don't know. Beyond a reasonable doubt, maybe. I mean, we're talking about anything that specifically identifies a defendant, whether it's a scar, whether it's the way they speak, the way they move. In this case, that familial relationship, if it's confirmed elsewhere, and I know there was a text or two back and forth that suggests that, in fact, they do have that relationship, and she's supporting that with her testimony, I think that's going to give the jury something to cling to. And let's face it, that's what juries want. They want to come to the right decision. You got to give them the ammunition to do that.
Well, here it seems like the prosecution is stretching a bit on some of the ammunition that the prosecution is looking for. Again, I keep going back to the eyewitness's account of what color the gun was. She said it was silver. The gun that they have in evidence is black. Again, it was at night. Lights bounce off of metallic objects in different ways. Could that be throwing the witness off, or is that enough for at least one member of the jury to turn around and say, hey, look, we've got no true eyewitness identification of these men. The one witness who did try to make such an identification was also making racist comments about African Americans on Facebook, so the identification could be colored with those comments. Again, is it a big problem for the prosecution? Because, in my opinion, it kind of is.
Well, it certainly gives the defense one more little nugget to chew at when they're giving their summation and their closing argument. Because who else was there to see those guns? Just one surviving victim. So that's something. I still think there are going to be people on the jury that say, look, we have shell casings, we have all kinds of other evidence that make that gun the murder weapon. The real question I think they're going to circle back to is who was holding that gun, because the ID is so shaky.
Yeah, well, we've got a lot more to break down in this case of the murder of a U.S. Marine Corporal Jonathan Price. He was 26 years old when he was shot dead in the parking lot of a tavern where he was celebrating his wife's birthday. His wife was with him. She saw most of the events go down. She called 911 and was unable to assist her husband because she herself had been shot on the leg. We're going to take a quick break. We'll come back with more analysis of the Jonathan Price murder case in a moment. Welcome back to Law and Crime, everyone. I'm Aaron Keller, and we're continuing to break down the case of the murder of U.S. Marine Corporal Jonathan Price. He was 26 years old when he and his wife were out at a tavern celebrating her birthday. They were sitting in the back bumper of a vehicle in the parking lot when the wife testified two men approached from different directions, demanded her purse, and that in an ensuing scuffle, her husband was shot in the heart and killed. The wife herself, Megan, was shot in the left leg. Her bone was shattered, and she was unable to even get over to her husband and comfort him in his final moments. Michel Byant is here with me on the Law and Crime Network to break this down. Michael, look, just a horrible story for these two. You've got a young widow now. She was up on the witness stand yesterday trying to remember these events, and look, I give her a lot of credit. She took her oath seriously. She said, this is how I describe the gun. This is the type of gun each man had, but I can't identify them in a photo lineup because I don't want to be responsible for making the wrong choice. She was very careful. I think that added to her credibility.
I think you're right, and to admit that flaw in her identification skills is not going to hurt her, but it doesn't help the prosecution so much either, because they got to be relying on the person there at the scene who had the best look.
Well, certainly the prosecution doesn't want to force someone to make a bad identification under oath on the witness stand either. But look, we keep going back to identifications. I give the widow credit that as much as she may want these two convicted, she's careful about testifying truthfully. We've got another witness who was on the stand who was part of this hotel robbery before the murder, Michel Smith. He made some troublesome identifications, and we're going to break that down now.
Yeah, I mean, he had the best identifications. Unfortunately, there may be some racial overtones to that identification based on the Facebook post that was brought to his attention while he was on the stand. Of course, he did that all in anger. That was just an angry moment.
Yeah, but then he's also saying in this testimony, and look, we're going to watch this in a second, folks. You've got to see this. He's saying, well, yeah, I picked this guy, but the guy who really attacked me had this other guy's nose. And it's like, well, then how did you pick the guy that you picked?
Yeah, this is not a Mr. Potato Head situation where you're taking body parts and putting them on a face and creating the guy you think did it. Did this guy do it? Did he not? And the photo array I got issues with, too.
Yeah, I mean, how they did it, they're flipping through the pictures rather than presenting the full array.
Right. It'd be like having a lineup in the police station where one guy parades in, take a look, he parades out, the next guy parades in, take a look. That's just weird. And I don't even know if it's weird is my way of saying I don't know if it's constitutional. I don't know.
In other words, it's possibly unconstitutional. Under my thesaurus, the new synonym for that is going to be weird.
Yes, there you go. Yes.
All right, well, look, this is really important testimony, folks. It resulted in a key moment of cross-examination. We're going to break this all down. Again, Michel Smith was one of the victims of a robbery in a hotel. He identified the two defendants who are on trial for murder now, but listen to the way he did it. Testimony there from Michel Smith, who was one of the victims of a hotel room robbery where prosecutors believe two defendants made off with a weapon that they then used to shoot and kill a U.S. Marine corporal named Jonathan Price, killing him and injuring his wife, Megan. Michel Byant here. We've got a lot to break down in this testimony from Michel Smith. One is the identification. He makes an identification of the defendants, and he sort of does it on his own as a threshold inquiry. But he says, well, you know, the guy I picked out looked like the guy in this photo, but I thought his nostrils were bigger. Maybe he was deliberately flaring them out.
Pretty interesting detail. It's to cover himself, basically, to say, if I am a little off on that, maybe this is why. It's just an odd way to go about it.
Yeah, I didn't realize that people in the acts of committing hotel robberies decided to purposefully flare out their nostrils in order to avoid recognition. You know, I mean, surely there are other ways to avoid recognition, like a mask or something.
Mask would work much better. Yeah, and I mean, is that something you notice in the midst of all of that craziness? Somebody doing something that subtle? I don't know. I'm surprised here during this testimony the defense was not jumping up and down and objecting to this kind of casual identification in court. Remember, here's a guy in the stand that if you're the defense, you're going to attack his identification from the bizarre photo array. And now you've got him just reinforcing who he says it is, pointing at him right in the courtroom. What about, it was this guy. Then he did this.
Yeah, this guy did this, and then that guy did that.
Defense doesn't object at all. At least make the prosecution lay some foundation before you make that kind of overt identification. The jury's just getting reinforced with, it's him, him. It was him, and him.
Well, if there had been an objection there, then presumably it would have then resulted in more attention being brought to it than not.
But I don't know how much more could be brought to it. I mean, that's a lot of pointing and saying they did it.
Maybe it was a strategic move because then the prosecution could turn around and say, oh, okay, well, you know, let's do the identification now. So, you know, then they skip ahead and then the defense looks like it's trying to stonewall an identification. Maybe.
Okay,
I don't know.
That may be giving them way too much credit, but I guess that's a possibility.
Maybe just in the deluge of verbiage that was slipping out of that defendant's mouth, it was just going so fast that the defense didn't get a chance to jump up. And then how do you really unring a bell other than to just say procedurally we want to force the state to lay down the tracks in this particular order?
Right. No, I think that's the way it should have happened. And if it was spinning out of control so fast, maybe the defense counsel wasn't used to that kind of back and forth, but they definitely had opportunities to jump up.
Yeah, this was a bizarre one. Okay, so one of the key points of this testimony is the way that the photo array was done, the photo lineup. We're going to get into that now, and tell me, folks, if you're watching from home, whether or not you think this makes sense the way you've seen other photo lineups done. There was testimony from Michel Smith, who was one of the victims in a hotel room robbery where prosecutors believe a gun was taken and that the gun was later used 6 days after the robbery to murder Jonathan Price, a U.S. Marine Corps corporal. Michael Byant is here with me. Michael, was that an identification or was that an attempt at an identification that we saw out of that witness?
I'm telling you, you know, hey, I see the guy in front of me now, even though my head was pressed down against the bed and I didn't get a great look. Now that I see
now that you caught him, that's got to be the guy.
Now that he's sitting there at the defense table accused of this crime, that's definitely the guy. I mean, that's horrible. It's horrible. And we have to remember, this is the crime before the crime. Mm-hmm. You know, so even if he was the guy then, and he and the uncle and nephew worked together on that robbery, man, it is a quantum leap to get to the murder. And you got a shaky identification for the foundation for the crime that takes place 6 days later.
You know, let's talk about the suggestibility here. And I know that defense attorneys are oftentimes dressing up victims. You know, look, we want them wearing a suit and tie. We certainly don't want them in front of the jury in restraints. We want them not in prison clothing. We want them to look as they would if they were out on the streets, perhaps headed to a casual dinner. Right. You know, but there's still the suggestibility that they're surrounded by deputies and whatnot, and it sends messages. And now you've got this witness up on the stand saying, oh, yeah, now that he's surrounded by all the defense attorneys and he's on the opposite side of the courtroom, clearly this has to be the guy.
Yeah, it's a very prejudicial environment, but you really can't get much around that. That's just the way the system is. You know, when you're the defense counsel, you're saying, you know, my guy is sitting here, but he is cloaked with the presumption of innocence. Okay, so don't get all caught up in the fact that we're here on the defense side of the courtroom and that there might be courtroom personnel nearby. They're doing their job, we're doing ours. My guy is innocent until proven guilty. You have to remember that.
That would have been a great way to start off the cross. Well, this witness was really critical, folks. We're going to continue listening to some of this witness's testimony now. Okay there, folks. Mitchell Smith, one of the victims of a hotel room robbery where prosecutors allege a gun was taken and then that gun was later used to murder a U.S. Marine corporal who was out celebrating his wife's birthday with her. So, Michael Byant, attorney, cross-examination skills. You've got this great piece of evidence for the defense, this Facebook post with racial overt or under the surface tones or both. That can be used to attack the identification and the bias of the witness. And it's only up on the screen for what, 10 seconds? I would have tried to leave that thing up on the screen for as long as I could. If I could milk 15 minutes out of it, I would be asking every single question under the sun about that post.
And first of all, I'm surprised you recognized me because I was flaring my nostrils just
then.
Well, I just look like a totally different person.
Well, your disguise was thinly veiled.
Yes. Yeah, you're right. I mean, if you've got a nugget like that, you better work on it, you know. Dig around, you know, make some points, reinforce this guy, if not a full-blown racist, obviously has some prejudices that may have colored his witness identification. But she didn't do it. She didn't dig. She didn't take advantage of it.
You know, look, a lot of attorneys subscribe to the cross-examination philosophy to never ask a question to which one doesn't know the answer. But I was at a seminar this week where I attended a session on cross-examination, and the speaker said that the way attorneys should view cross-examination is ask any question that you're going to be comfortable learning the answer to. And I think that this is an example of where that type of questioning could have worked.
Sure.
Okay, you've already
got...
Good answer. There's no good answer to this thing. You know, how often do you make racist posts on Facebook? Do you, you know...
How long have you been hating black people?
Yeah, I mean exactly. And if it's going to get hit with an objection, I'll move along, Your Honor. So let's talk about the phrase here. What did you mean when you said they all look alike?
Yeah.
Well, the attorney doesn't know the answer to that, but the witness certainly, there's no good answer to that question, so let him try to wiggle his way out of it. Yeah. What's he going to say?
Yeah, nothing
What do you mean by it? So in other words, sir, you mean that your own identification of an African-American man would, by your own words, be imprecise.
any of them you looked at look alike, so you were just throwing darts at a board, right, sir? I mean, it could have been anybody we put in front of you if they were black.
And it's horrible to let a question like that even slip out of my lips, but it forces this guy to eat his own words, and that's exactly what needed to be done there. And that Facebook post should have been up on that screen in front of that jury for as long as possible. Yeah. Let the jurors make the witness read it.
Of course.
Sir, can you tell the jury what you wrote here on Facebook? Then force him to eat his own words.
And
I mean, keep it going.
He said that post was done out of anger. Well, let's explore that a little bit.
How often do you get angry at African Americans? Yeah. I mean, this is the sort of cross-examination. And this piece of evidence didn't just fall out of the sky this day. They had time to prep on it, so I fault the defense for not making the best use of that piece of evidence.
We'll see what happens in the close. We'll see what happens, but they had so many opportunities here to discredit this guy. Remember, cross-examination is not only about ferreting out facts that you think were truth, but also discrediting a witness that's adverse to your client, the defendant.
Yeah, I mean, I think that you can try to make these points on argument, but you really needed to get something more out of the witness there. You needed to dig that out a little bit more. So look, folks, we're going to continue on with the cross-examination of Michel Smith. He's one of the victims of a hotel room robbery. And look, I understand that that's a horrible situation to go through, but the way that he reacted to it left a lot of issues with the state's case in the murder of Jonathan Price. So more cross-examination now of Michel Smith. That was more cross-examination from one of the witnesses in the Jonathan Price murder case. This witness didn't witness the actual murder, but rather was robbed in a hotel room 6 days before the murder. And the accusation that the prosecution is trying to ferret out here is that a gun was taken during that hotel room robbery that the prosecution believes was used to murder 26-year-old Jonathan Price, a U.S. Marine Corps corporal. So, Michel Byant, attorney. Here we started to see the cross-examination really break down what was going on inside this witness's mind. You identified this individual, but you didn't say anything about gold teeth. You didn't say anything about a facial tattoo. Well, these are identifying characteristics of the defendant. And he didn't go into detail. Okay, he said they were African-American. Were they lighter skinned or were they darker skinned? No detail on that.
Right. Almost as if he was going as far as he could the other direction to suggest he's not biased or bigoted or racist in any way. I don't see skin tone or color. I know they were African American, but light, dark, it's all the same to me. I think that was a little
which is contradicted by the Facebook post that we just watched, and that presumably the defense is the one that's skillfully brought up.
Yeah, and I think these things are important for her case, and I think she's doing a better job here. But it's not going to make up for the lost opportunity. I mean, she really had some opportunities. We talked about them. And doing the little things she's doing now, maybe just a little too late.
Well, we're going to take a break here on the Law and Crime Network as we continue to march our way through the murder of Jonathan Price, a 26-year-old U.S. Marine corporal. We're going to take a quick break. When we come back, we'll get you caught up on the top crime stories of the day. Welcome back again, folks. Keep in mind that we are in verdict watch here on the Law and Crime Network in the official corruption case of former elected district attorney Wallace Bradsher in North Central North Carolina. The jury has the day off in that case today, so when they come back on Monday, they'll be hashing over whether or not this elected DA broke the law when he engaged in a bizarre employment wife swap with a neighboring district attorney by the name of Craig Blitzer. Bradsher hired Blitzer's wife. Blitzer hired Bradsher's wife. It was a real back and forth. Ethics authorities knew that these two were trying to skirt the law and said ultimately, hey, look, okay, you guys can do this. We don't really like it, but it doesn't directly break the law, at least not right away. The issue really popped up when the state alleges that Wallace Bradsher, the defendant, was paying the wife of the neighboring prosecutor while basically not assigning her any work and instead allowing her to go to nursing school. So, Michel Byant, official corruption, what do you think?
That is a mess. Good job trying to put all those pieces out there.
I had to draw a chart early on in this case with lines and who was doing what in there, and then they were here, and then they were there, and it looked like a football playbook.
Well, you know, the thing that's missing from this case, I think, is any sort of sympathetic person. Okay, normally in a criminal case, even in a civil case, somebody's been wronged, right? And that's the person, if it's a victim, maybe their family is in the courtroom, there's somebody that the jury can kind of empathize with. And here, the jury members are the victims. Anybody watching the trial is a victim. It's the taxpayers who are the victims. So none of the players have any sympathy at all. Now, maybe Ms. Blitzer was... I know, I'm giving her a benefit of the doubt.
I had no sympathy for her whatsoever, but perhaps you didn't watch the testimony.
Well, no, I did.
Okay.
But at the point where she says, yeah, I know I was working, you know, doing nothing and getting paid because we needed the money. You know, I mean, at that point...
Yeah, so you know, I was really thinking about this the other day, and suddenly I had a moment of cognition, I guess. I don't want to say brilliance because for me that wouldn't occur. Yeah, let me know. You know, I'm sitting here saying, why didn't they go after the Blitzers full throttle here? Because they're the ones that ultimately were raking in the money while Cindy Blitzer wasn't working. And finally, some of the points that were made in the testimony made more sense to me because she said I was asking for work, but Bradsher wasn't assigning it to me because Bradsher apparently just wanted me to focus on my studies. So I guess in her defense, she was reaching out and he just wasn't giving her anything to do.
Right, and at the point where it became clear she wasn't going to work, she should have said, look, I can't in good conscience, you know, submit these pay stubs or...
And she allegedly asked her own husband about it, and he said not to worry about it. Well, that's why apparently that's why she wasn't charged, and the two husbands were, and one pled out to a much lesser charge than this guy.
Right, which is why he is not the target.
Yeah, the ringleader is this defendant who is left at trial. The other defendant entered a police, surrendered his law license. He's working as a pilot now. But that sort of explains why the charges played out the way they did.
So you've got now
maybe at least.
This just is, you know, it's so difficult with a government corruption case to find anybody on the side of the defendant because the government goes into any scenario down a couple of points. Yeah, there's just that feeling that, you know, the government's sticking it to us one way or the other. Now look, this is playing out right in front of us. I used to be a federal attorney for a short time. Couldn't do it because all of the inefficiencies, all of the waste, all of the lack of competence that people give the government credit for having or not having, I saw it play out, and I couldn't do it. I could not do it. It was frustrating, and I see the waste. Well, now you're seeing really an exaggerated version of that kind of waste. I mean, this is beyond just, hey, we threw some budget items down the drain that we shouldn't have. This is somebody manipulating the system for their own gain.
Yeah, and it got bad. Well, let's listen to some of the defense closings here. Again, this is Wallace Bradsher. Keep in mind, he was an elected prosecutor. Before that, he was a private criminal defense attorney. Now he's in the defendant's chair defending himself. Let's listen to him. Well, an interesting closing argument there from Wallace Bradsher, the prosecutor who was elected district attorney, who is now sitting in the defendant's chair. So, Michael Byant, what do you make of this? I mean, the judge sort of told him he had to keep himself on the narrow path there.
I thought he was going to shed a tear. I thought he was going to, you know, cry a little bit there at the end.
Well, look, this guy had a successful defense practice before he ran for prosecutor.
Yeah, he's obviously a decent attorney. He knows how to work.
He's too smart for his own good.
I don't know. I think this is a case where the jury's going to have to figure out, is he sorry because he did it or sorry because he got caught? I mean, what really...
Or is he sorry because he should have given more foresight to the issues that would pop up here and should have caught it earlier?
Yeah, I mean, he could be sorry about many things having nothing to do with the original plan to bilk the money from the taxpayers.
Yeah, I mean, I'm really curious to see how the jury's going to hash this all out. The jurors did have some questions yesterday, which the judge answered. We're going to get to those in a second, but first I want to bring you to the prosecutor's closing argument.
Beginning of the day.
Prosecution closing arguments in the Wallace Bradsher official corruption trial out of North Carolina, the case where a prosecutor is accused of business-wise swapping wives for employment purposes with a neighboring prosecutor in order to skirt ethics rules and then allowing the neighboring prosecutor's wife to draw a paycheck without doing any work. So, Michael Byant, The jurors asked a number of questions in this case yesterday during their deliberations. One was, what is the date range for obtaining property under false pretenses? They wanted specific dates, apparently, but does a date necessarily need to attach to that kind of charge? That's what's interesting.
It's very tough to tell in a vacuum what they're looking for. But in the bigger picture, I like to hear questions like this that are so specific. I mean, we know that this trial and any subsequent appeal is going to turn on jury instructions. And if they're tearing into jury instructions to get definitions, to get date ranges for whether it's a misdemeanor, whether it's a felony, I mean, they're doing their job. And they could easily just take the favor. I don't know. I have no idea what all of this means.
Yeah, I don't know what this is. And we've seen those cases before, too, and then I sit and complain about them. But look, you know, the charge that they're zoning in on in that first question is the felony. That's the top charge. Felony obtaining property by false pretense. They wanted to know the date range. The response back that was agreed upon and sent back to the jurors were April 1st, 2016 and October 24th, 2016. So there was an answer provided there. Yeah, so presumably they're looking at something in there as to who exactly was doing what, and they're trying to fit the facts into the law. At least that's what it looks like from the outside here. Perfect. Another question here, the second question for count 2, what does a representation mean? The second count, as I understand it, is the aiding and abetting count. I don't have the jury instructions in front of me, so I'm not sure quite how they're trying to, what they're zoning in there. What is a representation? Does that mean a statement of fact? Does it mean representation by counsel? That's what they really have to hone in on there.
Yeah, is it representing as in somebody says something, representing it to another person? I don't know. I don't know what they're looking for there. But again, if they're looking into it in that kind of detail, good for them, because it'll be more likely they get to the right result.
Yeah, third question here, excuse me, for count 2, does property only apply to salary benefits given to Cindy Blitzer, or can it include salary benefits given to Tyler Henderson or others? That's an interesting one, and here my fear is that they were maybe going off the rails, but they at least asked the question that it only applies to Cindy Blitzer. That's the conduct they're going after.
Right. It
Tyler
sounds
Henderson
like
was one of the other witnesses.
It's almost as if they're saying, is there any way we can find a broader wrong here? If it extends to benefits to others, maybe we're more comfortable finding him guilty of that type of crime. But if we have to focus it on one person, well, then maybe they do or don't have what they need, but at least they're asking.
Or they can't just blanket throw the crime in as a guilty without digging further into it. The fourth question they asked yesterday, for count 1, what is the legal definition of conspiracy, and can you conspire for just letting things go on, i.e., not being an active participant?
Wow.
That's really zoning in on the heart of the matter here. Did Wallace Bradsher conspire by not being an active participant? But I think that that question would get the state nervous, because the state's theory is that he purposefully didn't assign work and get involved because he was allowing the shenanigans with the Blitzers to go on so that his own wife could continue cashing her checks.
Right. So the question is active versus passive involvement in whatever was going on. And he's tried to shield himself, the former DA defendant there. He's tried to shield himself by putting some bodies in between him and the actual worker who wasn't working. And it sounds to me like the jury is trying to ferret that out and figure out exactly what his role was and what did he know was happening.
The answer that came back to that question, an agreement, in other words, a conspiracy, may be verbal or implied by the actions of the parties. Now, that's the kind of legal definition that the state is going to love.
Sure, because it broadens their interpretation of that rule, and if that rule applies more broadly, then maybe he's more guilty.
My guess is that the state really tried to bulletproof that answer. The judge really tried to bulletproof that answer. That's my guess.
Yeah. I mean,
that's got to be based in case law. They don't want to get overturned on that.
No, that's, again, jury instructions are going to be the appellate issues in most cases. Don't make it easy for them.
Yeah, so, okay, Wallace Bradsher case. The jury has it. The jury has the day off today. The jury will be back with deliberations in that official corruption case out of North Central North Carolina starting on Monday. We're going to take a quick break. We'll be back with more on the Jonathan Price case when we return. And welcome back, everybody. Turning once again now to the murder of U.S. Marine Corporal Jonathan Price. He was 26 years old when he was shot right in the heart outside a bar in the Lexington, Kentucky area. He was defending his wife in a robbery attack. He and his wife had been at that bar celebrating her birthday. It led to her injury. She was shot in the leg, a bone was shattered, and unfortunately, Jonathan Price, the primary victim in this case, died right there in the parking lot of that bar where he had gone for a celebration with his wife. We've got two defendants on trial in this case, Quincinio Canada and Dewan Mulazam. They are both facing a possible death penalty if convicted on murder charges, but from where we sit here on the Law and Crime Network, there are issues with identification of the defendants, issues with identification of the gun, and look, is it an issue for the state, or is the state proving its case beyond a reasonable doubt? Michel Byant is here to break that down and ultimately answer the question for us.
Boy, I wish I knew.
I wish I knew too.
I wish I knew. I mean, I'm sure there's something else out there that we've not yet seen or heard. But you know, the prosecution is working with some thin stuff to connect all the dots. I mean, every case is about connecting the dots.
Yes.
Here you have a big dot 6 days prior to the subject crime. The robbery, which resulted in the theft of the gun, which apparently was used as the murder victim.
Yes, and they believe that based on not recovering it from these defendants, but rather from ballistic tests. And oftentimes we hear that these ballistic tests are not horribly accurate.
Yeah, we've also had other scientific evidence that I think is really shaky. Some cell phone data, which I could go on and on about the whole cell phone data thing.
Yes, and the defense was attacking that. And the prosecution's trying to get at these guys through some clothing as well, saying that they had types of clothing that were believed to have been worn by the individuals here. But, you know, based on what I'm hearing thus far, I'm hearing things like Yankees hats. And look, I mean, if it was New York City, there are how many Yankees hats in the greater New York area? Millions?
Sure.
Probably. But this is Lexington, Kentucky. And although New Yorkers would like to believe that the Yankees are indeed the nation's team, they are not necessarily the nation's team. Okay, so you know, but some of this other stuff, you know, white shirt, black shirt. I mean, everybody's got a white T-shirt and a black T-shirt. Yeah. I mean, it's not a strong link.
No, it's horrible, and it gets back to the gun, which we've talked about before. I was thinking about this. You know, if you obtain a gun through a robbery, you're just doing what, you know, you've done it before. I'm sure you steal a gun from somebody. And what's the first thing you want to do? You're probably going to get rid of it because you probably don't really need another gun, but might be worth a few $100.
Well, you're making the perfect case for the prosecution. That explains how the gun got from these two defendants, if indeed they were the ones who had it, to this third party who tried to sell it to what turned out to be federal authorities, and that's how authorities got the gun.
Assuming it didn't go through other hands in between. I mean, this is 6 days. Mm-hmm. You steal it on day 1. You sell it to me on day 2, make $50, $100, whatever. On day 3 or 4, I sell it to 2 other guys. You know, we just don't know, and there's way too much I don't know about that gun.
Yeah, I'm waiting for more of these threads to be tied up. Sometimes these cases become much stronger as we march through them. The state still has the case, and we've only really listened to about a day of testimony here, 2 days of testimony. But we want to bring you back to the prosecution's opening statements in this case, because there we got a preview of the evidence the prosecutors thought would come out in a trial. The question is whether or not the actual evidence that's spilling out from the witness stand matches the prosecution's promise during these opening statements. So let's key in on what they said. And a lot changed in the lives of Jonathan Price and Megan Price, his wife, in those split seconds that we saw in that surveillance video. I was getting a bit confused about this because, Michael, at one point during the statements, it was like, well, you don't really see the shooting, but then there it was pretty clear that the flash from the weapon went off, or what's believed to be the flash from it.
Yeah,
so you don't see the victim getting hit, but you see the flash from the discharge from the barrel, presumably.
And I think that is a perfect example of how to do a good opening where you're using visuals. You know, people like show and tell. Mm-hmm. And this prosecutor was very good at looking at notes, but really talking. She's talking to the jurors and having nice little videos and to illustrate her point is the way to go. I get the feeling that the prosecution is hoping that they lay out enough evidence of the underlying robbery from 6 days earlier at the Dewdrop Inn or wherever that
quality or whatever it was,
that they will just make that leap for her. Crime happened there, gun identified there, gun stolen there, gun identified in crime number 2. Done deal.
And you have these issues about whether or not the gun was silver or black, because the surviving victim Megan Price, the wife of Jonathan Price, testified yesterday that she thought the gun had a silver barrel. Well, the gun that's in evidence is a black weapon.
Yeah.
Okay, same type of weapon. It was a semi-automatic, not a revolver. But, then you've got testimony from the guy from whom the gun was stolen, and he said that the paint was in the process of wearing off of the gun.
Yeah.
So just how much of it was worn off? I'm really waiting to see this weapon and really get a close look at it, a close-up shot of it in court, so I can figure out what's going on.
That'll be more dramatic. There's no doubt about it, because now we've laid the foundation for this question about the black gun. Is it the black gun with the silver barrel? Is it just worn out at the front end? Because the picture we've seen, which is just a two-dimensional, makes it look pretty darn black all over.
Yeah, I mean, and look, I mean, maybe that's just the light that the photo was taken in. Who knows? And, look, did the victim, Megan Price, you just saw the recording there. This thing went by in a split second. Did she get a good look at it?
Yeah, and again, as I mentioned earlier, the flash of the gun going off, all the chaos, that's not a crazy detail to miss. But if I'm the defense, it's one that I'm going to focus on.
Yeah, and is it enough to raise reasonable doubt? That's, of course, the key question. So, look, we just listened to some of the prosecution opening statements. We're going to continue on in our review of testimony in the Jonathan Price murder case out of Lexington, Kentucky, the case of a 26-year-old U.S. Marine corporal who was shot and killed in the parking lot of a bar. You just saw the video. As I said, we just heard from the prosecution. We're going to listen to one of the witnesses now. This is Shane Handworth on direct testimony.
Down to the store.
More testimony there in the Jonathan Price murder case, the case of a 26-year-old U.S. Marine corporal who was shot while protecting his wife in the parking lot of a bar where the couple had been out celebrating the wife's birthday. Michel Byant, here we've got another one of these witnesses who was in the hotel where another robbery happened 6 days before the murder, and where prosecutors believe the gun was stolen. And he's basically going through the serial number and whatnot, try to get evidence of the weapon that was taken from them into evidence in this case. This was the weapon, this was the serial number, this is how we know it was ours.
Right. This was his gun, so he's the one with the most intimate knowledge of that weapon. And, it's something the prosecutor's got to lay as a foundation, because if you're going to rely on that gun being the murder weapon, you better lay the foundation that it was, in fact, the one that was stolen 6 days earlier.
And how do we get it from the hands of this witness to the hands of the defendants to the hands of the person who sold it to the authorities some point after the murder happened?
Yeah, and to me, to be honest, I don't really care how it got to the authorities ultimately. I care about what happened between the robbery and the murder. That's what I care about. Because
well, I care about what happened after the murder, too, because it presumably changed hands at least 3 times here.
But in terms of pinning it on these defendants, it's the days between the two crimes that really matters. Because it could have gone many places after the murder. Not as important. The fact that they got the gun ultimately obviously is very important. But where was it in those 6 days? How many people had it? How many people touched it? Who shot it?
And does the prosecution necessarily need to prove that, though? Well,
they're laying out this kind of theory that it must be. Here's where it was, and it was used in the murder. Same guys stole it. They're sitting here today. Therefore, jury members, it's obvious. The connection is simple. Don't make it complicated. It's very simple. But it's just, to me, such a glaring truck driving through sized hole. I gotta know more.
Yeah, I mean, I want to know, okay, is it the gun? Does the description match what the witness said? The ballistics, we know that sometimes those are open for controversy. The cell phone records that try to put these two in the area, aren't necessarily accurate all the time either. Or is this going to be a case where there's a maybe, a maybe, a maybe, a maybe, a maybe, and there's so many maybes that the jury's going to turn around and say, you want to know what? These two were at least in the vicinity based on the cell records. The description, the conversation back and forth, even if the descriptions are off a little bit, they're referring to one another as, uncle and nephew. Add it all up together, and it looks like not just coincidences all, but rather a series of clues that ultimately point to these two defendants.
And that's what they have to do. And I like the uncle-nephew reference. I think that's pretty specific. Unless I'm hearing some evidence somewhere from a cultural expert or somebody that tells me that's common. It happens between friends and family members and buddies. unless I hear that, I'm going to think that, that's pretty specific and unique. It's not, Ishkabibble and Smith. It's not that specific, but it's pretty good. So I think I'd rely on that and hope that the common sense carries the day.
Yeah, it may just be a pile of too many things that are not coincidences that could result in a conviction in this case. Detective Timothy Upchurch was one of the other witnesses who's testified thus far in 2 days of testimony in the trial of the murder of U.S. Marine Corporal Jonathan Price and the injury of his wife. Let's listen to Detective Upchurch's testimony now. That was Detective Timothy Upchurch talking about the tracking down of this gun that authorities believe was used to murder U.S. Marine Corporal Jonathan Price and shoot and injure his wife as the two were outside a bar where they were celebrating that wife's birthday. So, Michael, they're going through a lot of pains to try to zero in on this gun. Serial number, this is when police got it, this is when, they did tests on it, this is how they handled it, everything surrounding this gun.
Almost everything. Almost. I mean, they're playing with what they've got to play with. They know how important the gun is. It's the MacGuffin I may have mentioned. It's driving this story. It's driving this case. It's driving the characters. But I want to see more. And over the next week, as this plays out, I want to see that window closed down so that we know a chain of custody for that gun. Was it under the pillow of the defendant for the whole time he had the gun, from the robbery to 6 days later when it was used to kill this Marine? Show me that. Prove that to me.
We've got the gun, we've got issues as to whether or not the surviving widow's testimony indicating it was a silver gun when it was really a black gun. Does that do enough damage to the case? It's certainly a gaping hole in the testimony, but in the evidence, I should say. But look, the ballistics apparently match this up to the bullets that were used in this thing. And look, it was a stolen gun.
I think it was the murder weapon. I don't think there's a question. It was the murder weapon. That's great. So how many people could have used that as the murder weapon? When the identification is so weak and so racially charged in at least one witness's mind, it waters down the fact, and the jury can't overlook the fact that if it's the gun, we still need to know who pulled the trigger.
Yeah, a lot of other issues with the case that the defense brought up. You've got someone else's DNA attached to the victim's fingernails. If there was a scuffle, could there have been a transfer of DNA, and why isn't it these two defendants?
Exactly.
Why is it that someone else raised issues about whether or not there was a another attorney in town who had a tip about another case? So all these questions are ringing true.
Good teasers.
Yeah, we're going to wait to see this case continuing. So Michael Byant, appreciate you being here.
Nice to see you, Aaron. Always fun.
All right, we're going to pitch now to the documentary that we here at Law and Crime put together about the Holly Bobo murder trial, all of the twists and turns that case brought to us. I'm going to sign off for now. Vincent Hill will be back about an hour from now. So he will see you then, and I will see you next week. Now, Holly Bobo, who killed her?